and you mentioned this a little bit before, but let's take a little deeper dive here. Overcharging. And I think you've addressed it to a certain extent, but let's address it directly. All right, a lot of people looked at this case and they said, yeah, manslaughter. This is a manslaughter case. It's obvious manslaughter. It's not murder. This isn't a murder case. Why are they overcharging? And two things it does. It's overcharging because you're vindictive against Zimmerman for whatever reason, you know, whether your motivation is, you know, the public pressure or whatever else is going on. And number two, yeah, well, you're hoping for a compromise down the road. You're just going to shoot high and, you know, if they compromise, we still won.
Well, as you well know, our ethical obligation is only to charge what we feel we can prove beyond a reasonable doubt. Three things. Number one is the words he uttered when he was describing Trayvon Martin, don't those show ill will, hatred? Don't they show more than just like, oh, he's a nice guy? Number two is a judge found probable cause at the very beginning. Number three is a judge at trial denied motion for judgment of acquittal, not once, but twice. So now you're saying that a judge didn't know what they were doing? A judge who didn't always rule in our favor, a judge who I thought did a great job, was fair to both sides. Did we, like, convince the judge to do something improper? Didn't the judge find that there was enough evidence of second-degree murder? So whoever's out there talking about there wasn't enough evidence, they're not just criticizing the state. They're criticizing a judge who sat through the trial and heard all the evidence.
And there's somebody out there that keeps yapping about the original arrest affidavit. Well, yet another judge found probable cause. The defense never once attacked the arrest affidavit. So why did the prosecution do anything wrong? We were supposed to put the picture of George Zimmerman's bloody head in the arrest affidavit, and then what? Put the picture of it cleaned up, put the medical records in also that show it was barely a cut, it needed no treatment, or maybe a picture of the PA going, it was this big. Really? We're supposed to put our entire case into an arrest affidavit? The arrest is based on probable cause. The other thing, I hear that people are saying, well, they didn't take it to a grand jury. And Vinny, you know what they say about us as prosecutors when we take something
about a
to a
ham
grand
sandwich,
jury.
right?
Something about a ham sandwich. So these people really need to sit back. It's almost laughable what people who are supposed to be law professors and lawyers and even a couple of judges are saying without understanding Florida law. Had we done anything improper, these excellent judges in Seminole County would have closed this case down.
Let's get back to manslaughter. Lesser included, you knew it was coming in all along, but I didn't hear in your case or in the closing arguments a legal roadmap for this jury to say A plus B equals manslaughter. And they even sent a note looking for some more guidance. You think you should have given them a little more guidance maybe during your case or in the closing argument?
I thought we did, but you know, I don't know what those jurors were thinking, but it's very basic. It's just intentionally shooting without malice or, I mean, it's not a premeditated intent, but it's just an intentional shooting. He shot them, so there's no dispute. So I don't know that that was that complicated.
I think one of the things with justifiable use of deadly force, it's like an insanity case, Vinny. Generally, the defendant's admitting the criminal acts, basically. Yes, I shot him. Yes, I did this. Yes, I did that. However, legally, I'm not guilty because it was insanity. It was entrapment. It was justifiable use of deadly force. So we focused on disproving the self-defense, which is what we believed we had to do. The act was apparent. The question was was it justifiable? It wasn't even, did George Zimmerman shoot and kill Trayvon Martin? It was he justified in the deadly force? So we focused our attention on addressing that, not on what kind of crime is it. Was there a robbery or not a robbery, which would be first degree? You know, was there hatred, ill will, spite, or evil intent? We believed there was based on his demeanor and his mindset. But the bottom line is, our case clearly disproved George Zimmerman's statements of self-defense, clearly disproved that. However, this jury ruled on all the evidence. And to this day, maybe they believe George Zimmerman did this and was almost justified in doing it, and that we couldn't meet our burden of proof beyond a reasonable doubt. That doesn't make anything about this dishonorable. It makes it how this great system of ours works. People should be applauding the fact that in their minds, if they believe George Zimmerman used justifiable deadly force, then the jury found that. And that's why we try cases and put it in the hands of the jury.